Okay. Good morning. Good morning, everyone. So I see people are joining the webinar. We're going to give just a couple minutes for people to get in and get settled. But I want to extend a very enthusiastic good morning and welcome to this presentation. Let me share my screen so we can all see what we're doing today. One moment. Okay. All right, sending another welcome. I see people are joining. So this is the Estate Planning 101 Time is of the Essence presentation, and it is presented by CIC, Community Investment Corporation, in conjunction with JP Morgan Chase and J. Selmer Law. So again, I see people are joining, and welcome to those of you who are coming in. We had a very nice response in terms of registrations. So since we are expecting a nice number of people, I'm giving just a couple minutes for people to get logged on and get started. Also, to let you know, this presentation will be recorded. It is being recorded actively now, and it will be available for later. But still, we'll give maybe 2 more minutes for people to join. We're really happy that you're here today to see this presentation. This is a first time for us to present a topic like this, and we very much appreciate JP Morgan Chase staff for reaching out to us to offer to present this information to our audience. So big thank you for that. Okay. I see our numbers are still increasing. Right now, it looks like there are 55 of us on the call, 55 attendees on the call. So that is great. And yeah, we'll give it maybe about 60 more seconds before we jump in and get started. All right, this is really an exciting topic for a lot of people, because a lot of people spend a lot of time doing financial preparations, finding ways to make the money. And this is a chance for people to have a better understanding of what to do once that income is generated. So again, we're really excited for this topic today and excited for you all to join us. And I think maybe, hey, let's go ahead and get started. Again, the session is recorded, so anyone who joins us later will be able to access this information. So again, welcome to Estate Planning 101, Time is of the Essence. This presentation is brought to you by Community Investment Corporation, CIC, JP Morgan Chase, and J. Selmer Law. A little bit of a rundown of the agenda today. So the welcome will be provided by me, an agenda overview, and then we will have the panelist introductions, and you can see who's joining us today. What will follow is the estate planning presentation, which will be done by J. Selmer Law and JP Morgan Chase. I'll follow that with next steps, what will happen after that, and then we will go into small breakout meetings. We're trying something new to enable us to have smaller groups to allow for more of an opportunity for people to ask questions and to get more detailed answers for that. Okay, all right, let me stop sharing my screen and talk a little bit more about what we're doing. So again, I extend an enthusiastic good morning to those of you joining us today. My name is Erica Miles, and I am the Training and Technical Assistance Manager for Community Investment Corporation. Before we begin, I would like to acknowledge those who are in our audience today and find this topic of interest. So we have current property owners from the CIC community, prospective property owners, and people who found this event on social media and care about their financial futures. Attendees range from those who are retired or nearing retirement, all the way to those who are just starting out or starting families with an eye toward the long term. There are single parents, members of two-parent households, and singles without heirs. In addition, this presentation, as I mentioned, is being recorded, so we hope for it to be a resource to viewers in the future. Whatever category you fall into, we see you. Well, not literally, we don't see you, but we're glad you're here. Many of the observers in this presentation own property and provide affordable housing. You fill a vital need in many communities. Having safe, desirable, and affordable places to call home is the foundation for people who contribute to strong communities. Many of you in the audience make that happen, and you are to be admired for that. Providing affordable housing is very important. However, another motivation for many people who choose the path of real estate investment is to champion the economic outcomes for their families and other loved ones. There are those who strive for financial independence and to climb off the hamster wheel of living paycheck to paycheck during their own lifetimes. There are singles without heirs who would like to leave gifts behind for cherished institutions like their alma mater, church, or other beloved institutions. There are those who seek to establish generational wealth and pass both money and financial lessons on to their children. In fact, I've known investors who purchased a property at the birth of each of their children, name the building after the child, and apply the rental profits to planning for that child's college education. So after you make all of those sound financial decisions and your hard work and sacrifices pay off, what happens to the fruits of your labor when you're gone? How do you protect your estate and ensure that the resources you leave behind go where you want them to go? This is what we want to talk about today. Before we get started, I would like to share a little bit about our organization. Community Investment Corporation, CIC, is a mission-driven lender that improves and preserves rental housing throughout the Chicago region. Our clients tend to be small, local owner-operators of quality, affordable rental housing. CIC has been active in the Chicago area since 1974, and we're looking forward to celebrating our 50th anniversary. CIC specializes in the purchase and refinance of multifamily buildings with 5 or more residential units. We operate in Chicago and 6 Collier counties, but we specialize in the South and West sides. Our borrowers range from small family-owned businesses with a handful of units to large and experienced developers with a few thousand units. We are willing to work with those who share our vision for vibrant communities. I'm also excited to tell you a little bit about our property management training program. We offer both in-person and virtual property management training to current and prospective property owners. CIC, I'm sorry, our next in-person training will be this coming Monday, October 30th. There's still space available, and for details, you can log on to our site. To stay informed about our property management trainings and other webinars like the one you're watching, please sign up for our mailing list. You can go to cicchicago.com, check the program tab, and find property management training. You can also email me at erica.miles, erica.myles @cicchicago.com. We want to say a huge thank you to our partners on this call from J. Selmer Law and also JP Morgan Chase. And we want to say a particular thank you to John Golar of JP Morgan Chase for his idea of providing this valuable content to you. And now I'll hand it over to Rochelle McAllister. Oh, Rochelle, you're muted.
Thank you. Thank you. Thank you, everyone. And again, not to take away from all the wonderful things Erica has already shared, we are delighted to be here. I'm happy to also be a member of the Chicago Pro Bono Committee, and I've in working along with Elizabeth Riddle and John to put this event together. And a little bit about me: I have been with JP Morgan Asset Management for about a little over a year, maybe about 16 months at this point. And my specialty is actually in real estate investment funds. And so this is really a special area for me to be able to speak with all of you all and assist where we can during this pro bono week of service. It's very important for us, and I'm happy to be here. If you have any questions, and I look forward to speaking with the people in my breakout session further. Thank you. I'll now hand it over to my next colleague here. Elizabeth?
Hi, Elizabeth Riddle, JP Morgan Legal. I support our trust and estates practice, so very glad to hear what James Selmer and his law firm have to say, and happy to support CIC. John?
Yes, good morning. So good morning, everyone, and extremely excited about this event. This is kind of our inaugural event to be working with CIC in this capacity, and looking forward to working with each of you. My name is John Golar. I am one of the other real estate attorneys here at JP Morgan. I am in the community development space, so I work with a lot of community development projects here at JP Morgan. And I just think this is a really great opportunity. I wanted to extend a real thank you to Rochelle and Elizabeth for the work that they've done internally here at Chase as we all kind of work with pro bono efforts. Now I kind of wanted to hand it over to the law firm who's going to be providing the remaining portion of our informational session here. Just a little bit about them. J. Selmer Law is a Minneapolis-based law firm that was founded about 40 years ago by attorney James Selmer. He's a graduate of the University of Wisconsin Law School, and J. Selmer Law is actually the longest operating minority-owned law firm in the history of the state of Minnesota. So that is an awesome achievement. The firm provides a wide variety of transactional litigation services to Fortune 500 businesses in Minnesota, Wisconsin, North Dakota, South Dakota, and is also a member of the National Association of Minority Women-Owned Law Firms. They're a preeminent organization which is a preeminent organization of prestigious law firms who have distinguished themselves by providing high-quality legal services to major governmental agencies and Fortune 500 companies. Some of their practice areas include commercial litigation, complex business disputes, banking and finance law, employment law and investigations, real estate and real estate litigation, so real estate transactions and litigation, general liability, negligence issues, insurance law defense, and of course, one of the areas that we're working on today, which is estate planning. To date, they've worked with a number of matters with JP Morgan, and they've handled a number of kind of litigation matters across the country. So at this point, I want to hand it over to James Selmer and J. Selmer Law so that they can provide some brief introductions for themselves. So thank you all, and I'll hand it over to James at this moment.
Good morning, everyone. I'm James Selmer, as John said, founder and managing partner of J. Selmer Law. I've been practicing 40 plus years. The panelists today from the firm are knowledgeable folks, and I manage the day-to-day operations of the firm, so I'm going to turn it over to those folks. Next up is Alan Gibbous. Alan?
Okay. Hi, I'm Alan Gibbous. I'm a graduate of the University of Minnesota Law School in 1974. I'm going to be later talking about wills. I drafted my first will in 1973 when I was still a law student, working to raise some cash for law school. by doing clerking work for a Philadelphia attorney. I think that's probably all I need to say for myself now. I'll wait till I have more talk about wills.
Okay, I'll go next. My name's Mark Berg. I'm an attorney. I'm also a graduate of the University of Minnesota Law School in 1990. So I've been a lawyer now 33 years. I've been with J. Selmer Law, I believe 23, possibly 24 years. And if you heard our list of practice areas, I've been in all or most of those. Even though I've been a lawyer for about 33 years, estate planning is something I've started working in at about, I want to say 10, 12 years ago. We've done a lot of work for individuals and couples in this area to help them with their planning. I'm going to be getting into that a little more, but next I'd like to turn it over to, I will mute myself, stop my video, turn it over to our fourth firm member here, Tony Chin. And Tony, and when you're done, you may want to share our PowerPoint, okay?
Gotcha, Mark. Hi, everyone. My name's Anthony Chin, Tony for short. I'm a graduate of Mitchell Hamlin Law School, and I work as associate pending admissions to the bar here at J. Selmer Law. I've been with the firm for about 7 years now, and I'm excited to be here today.
Okay, we want to get started. Tony, can you share the PowerPoint? Great, there we are. Thanks. All right. I introduced myself. I'm Mark. Here's our pictures. Tony, how about next slide? Again, this is a slide on our firm background. James went into a little more, and John went into a little more detail. So let's get into the subject matter. Yeah, Tony, go to that objective slide. Thanks. We were asked by the folks at JP Morgan's Chase to provide what they call a high-level overview of the estate planning principles. And so our objectives today with you all is to give you something in the area about knowledge of the principles and importance of estate planning, understand the process and steps, determine who needs estate planning. And quick little spoiler alert for you, the answer to that is just about anybody. So if anybody asks you that question. Also some knowledge about the types of assets you can transfer and the ways of transferring those assets. So Tony, next slide, please. What we want to say by way of introduction is that the reason we're here is to, and you want to be interested in estate planning, is to talk about how you protect your legacy. And I'd like to, just building on some of Erica's comments earlier, and I agree with everything she said about how this ties into building your wealth, but understanding how you preserve it through a legacy. I thought that was great. When we talk about estate planning, sometimes people will put it off, I believe, based on my experience, because it's uncomfortable. It involves thinking about your mortality, thinking about death, thinking about money, thinking about family issues. And so what we want to get across, if anything, today is that it's good to do this and do this early and be consistent with it. And the way we make this point is by just pointing out some famous examples. The names of the celebrities you see listed here died without a will, or I think maybe in the case of one of them, died with a will that wasn't very good. And just by way of bullet points, 3 and 4 here, heirs battling over multi-million-dollar estates. Our point is the lack of good estate planning in these cases led to a great big legal mess that nobody wanted. Our firm was actually involved in one of these. I'll let you guess for yourself which one, but it's the celebrity who has something to do with Minnesota. And we, along with what seemed like half of the Hennepin County Bar Association, ended up somehow getting involved in that case. But what we want to say is, don't be like them, leaving your estate in chaos. And if you do good estate planning, you could avoid spending money on unnecessary estate taxes and attorney's fees. So Tony, how about the next slide? The starting point in any discussion of estate planning is to start with this concept of the estate. So let's talk about what that is. And as the slide shows here, it says the first term is that your estate is all property, assets, accounts, and property owned, and I would add to this, outright by an individual. And then after we say, okay, everybody has an estate as of the time of their death in some form or another. What we do for the estate planning process is we start to think of, do you have a small estate or a large estate? And the reason for that is you know, that becomes part of the decision tree in your estate planning process. Is if you're a small estate, you don't have the amount of assets that will require that you start thinking about avoiding estate taxes. If you have a large estate, which is property valued close to, at, or above a state or federal estate tax threshold, that's when you should start thinking about those. By way for examples, currently there is a federal estate tax threshold. It is very, very high, 12 million. It's over $12 million now. Some states, 11, I think now in total, have their own estate tax. Minnesota, here where we are, it's $3 million. Illinois, where I believe most of you are, is $4 million. 11 states have that. Most states have no estate tax. 5 states have what's an inheritance tax, where anything that you inherit is taxed to the beneficiary. One state, Maryland, has both an estate and an inheritance tax. States without either of those, including Wisconsin, and I'd also mention Indiana, you worry about estate taxes if your gross estate is going to be somewhere in the neighborhood of 12 million or whatever the federal estate tax threshold will be at that time. It was raised a few years ago. I don't expect it'll be raised again anytime soon, but who knows? Tony, let's go to the next slide. Further about what your estate is, and your spouse's estate if you're married. That's going to depend on various factors. It depends on local laws, the years that you're married, if there's a prenuptial agreement in place, if property is owned jointly or individually, that is like real estate, if it's titled joint tenancy versus an individual fee owner. Some properties may be classified, again, this is according to state law, the state where the property is, as marital property, meaning the value or part of it will be calculated as part of your estate. Some jointly owned property accounts or real estate may pass automatically to your spouse by operation of law and will not be considered a part of your estate. A couple little points before we leave this, and I want to add them. Some common examples are life insurance. Life insurance proceeds will generally not be part of your probate estate because those proceeds will pass to the named beneficiary by way of a life insurance policy is basically a contract, and it says life insurance company upon your death will pay money to this named beneficiary. Same thing often that we come into is questions about retirement funds. Retirement funds will typically have a named beneficiary, and the funds will go to the named beneficiary per those instructions, and then will be out of the probate estate. So it's a couple of examples there. So Tony, next slide. So kind of the principles we follow with respect to how we do estate planning. You want to take time to think about and understand your personal family goals, budgets, and needs. What do you have? What do you plan to leave it to? What's important to you? That sort of thing. Another principle is, and this is why you're working with a lawyer to do this, is to understand applicable federal and state laws to reduce paying taxes. Also planning early. Again, I mentioned before, life can throw many curveballs. You want to obtain the advice and guidance as early as possible. Connect with a good estate planning attorney and follow up as appropriate. Okay, Tony, next slide. Briefly, kind of an outline of the steps of what you're going to be doing when you're an estate planning client. And this is kind of how we see it. First we'd say you consult an attorney. One little point here is a lot of people will say, well, why don't I just go online and get myself a form and modify it myself? Why do I do it? That's not recommended. You're not saving yourself a ton of money by doing that, or time. It's just consult with an attorney on this, work with an attorney. It will be worthwhile. Second, you're going to gather all relevant information. And when we get to the end of the breakout sessions, we're going to go over the checklist that we use to get a complete as possible understanding of what you need, the type of information you need to gather in order to do this. Third is to determine your financial status. That's also a function of going over this whole assessment of what your assets in estate may be. Fourth, you're developing a estate plan, that is planning your goals and short list of contingencies, doing a check about, is the person, and every lawyer who practices in this area does this, is this person who's preparing the will or trust or what have you, do they have testamentary capacity? Are they of sound mind and body to be able to make these decisions? Fifth, implementing the plan don't work. Again, work with estate planning, turning to draft the documents and as needed. And again, I like to say, some people are uncomfortable getting started with this process, but in each and every matter I've been involved with our clients, I know that they tell us, or I know that they feel they're glad they did this. And then the sixth point is to review your estate plan periodically. I like to say that there's estate planning review moments. Common one is if you're a couple who came in for estate plan and several years later, one of the spouses died. That's an estate planning moment. That's what I told my own mother after my stepfather died. I told her, get together with an estate planning attorney in your state. Also, Tony was talking about how more recently been talking about world events such as the pandemic that could change things. And so with this, I want to turn over the presentation to Alan Gibbous, who's going to get into a little more detail about wills. So Alan.
Thank you. So I drafted my first will in 1973. Since then, I've drafted hundreds and hundreds of wills. And a common expectation that people have about wills is that it's going to basically be a magic bullet. And I'm here to tell you it's not a magic bullet, but it is a very, very, very useful tool. It is not a magic bullet, but it is kind of like a map. It creates a layout of how to get from where you are to where you want to be. In my experience, the primary benefit of having a will is that it gives the person who's writing the will peace of mind. And at the time of that person's death, it gives all of their beneficiaries peace of mind because the person had the foresight to take care of things, anticipate problems, and lay out a plan that actually enacts their principles and values in life. And it helps to avoid disputes between people who have different opinions about what ought to happen with the decedent's assets. It does other things as well, though. So basically, a will is the document that kind of tells who the beneficiaries are and tell who's entitled to what. Of course, each state has its own laws, but generally speaking, the laws of one jurisdiction are similar to another. But again, because the laws do differ, it's really important to check with an attorney who has knowledge about the laws of your particular state so that the document that gets drafted is actually capable of carrying out your intentions and wishes. The will does allow some control over the distribution of wealth at the time of death. It allows you to name beneficiaries. Next slide, please. A will is a testamentary instrument in the sense that it only goes into effect after the decedent dies. A very important benefit of having a will is, as I suggested earlier, it diminishes the likelihood of disputes between people who are beneficiaries. That helps to reduce the time and cost of administering the estate. A good estate plan will have thought about all those kinds of things and will have structured the plan in such a way that also emphasizes efficiency and cost effectiveness. Having a will allows the decedent to name someone to serve as their representative. I always recommend having a first, second, and third choice because in my experience, the time that I draft a will is separated by many years from the time when an individual actually has a need to employ it. So I like to provide for a variety of contingencies so that the individual's wishes actually have success in being achieved. A very important factor of wills is that they are flexible. Even if you do not have assets, significant property assets, if you have children, you should have a will, because a will allows you to name the people that will function as the guardians of your children after you die. And that's a very, very important thing. It also helps you have discussions with the people that you nominate for this position so that they have a clear understanding of what your wishes and values are, so that they're really well positioned to carry out your wishes at the time that the need arises. If you have a beneficiary who is disabled or somebody who's dependent upon government benefits to survive, you need a will, because you probably need to put in a supplementary needs trust so that if you give assets to a beneficiary who's disabled and they get them directly, sometimes that will disqualify them for receiving the public benefits, and they'll end up basically with nothing. So you'll need to set up a supplementary needs trust so that the individual can receive benefits over a stretch of time that's consistent with what their needs are and the lifestyle that you believe that they should have. So wills can establish trust. The other important factor about wills is that most states have provisions that determine who's going to inherit your assets if you die without leaving a will. And if you want to have beneficiaries who are not blood relatives or are charities or friends or things like that, you need to include them in the will, because the laws of most states would not include them. Let's see. Most states have provisions that forbid you from disinheriting a spouse unless the spouse consents. Next slide, please. So who's a beneficiary? Basically, anybody that you name is a beneficiary. And let's see, this is again an area where it's important to have your values and priorities in life reflected by the beneficiaries that you name. If they're entities that supported you at a point in your life and you want to support them, you have to name them in the will in order for them to be included. The beneficiary can be heirs. Those are the people who are legally entitled to benefit from your estate, and non-heirs, which is basically others. Next slide, please. So how does a will operate? Just basically, a will creates sort of a structure for the collecting of the individual's assets. I should say one thing. A will only deals with assets that are considered probate assets. And I think Mark already explained that there's some assets that are significant assets for many folks, such as retirement accounts, IRA accounts, 401k plans, and life insurance plans that are not necessarily probate assets. So if an asset is a probate asset, then it is something that will be covered by the will. And the will, of course, basically obligates your personal representative to collect your assets, to pay your bills, and at some point distribute the assets that you have to the people you've identified as entitled to them. Now, there is something in this particular section mentioned, a specific devise. A specific devise is a part of a will where you identify a particular item of property and identify who is entitled to receive it. As a general estate planning practice, I discourage clients from listing a lot of specific devices, because when I was early in my practice, I had a client who was the favored grandchild. And the favored grandchild ended up at the end of everything with almost nothing, because a large portion of the decedent's assets were given away as specific devises. And it meant that the person who was expected to receive the primary magnitude of the estate actually ended up with the least, because too much had been given away. Next slide, please. So a will can be drafted. It also can be revoked, or it can be amended. So a revocation has to be done knowingly and intentionally. A will also can be amended. In the early years, I used to have a separate document called codicil. In more recent years, I've tended not to use codicils, because I have on my computer the person's individual will, and I found it much easier to amend the original will than to create a separate document called a codicil. But again, a will can be amended, can also be revoked. There's also something in estate planning called a separate writing. So most states have some sort of provision in their probate law that allows a person to identify a particular item of personal property and put that in a list. And then if they decide to change their mind about what specific item of property a person is to receive, if they change their mind about that, they don't have to revise their entire will in order to see that that intention is carried out. They just need to change the separate writing. If you do a separate writing, be sure to check it from time to time, because sometimes you change your mind about who's entitled to what. Sometimes things get lost or destroyed, and it's best to keep things up to date so that things are in a certain order at the time of death. Next slide. So a probate is the court supervised process of basically carrying out the wishes of your will. Now, you can have a probate proceeding without a will, and the state law of the particular state where the individual lives will basically control that. We are encouraging people to have wills, because you can exert more influence and more direction by having a will than not having a will. Many people think that the probate process is burdensome because they've seen an advertisement that says that it's time-consuming and costly to have probate. Increasingly, states around the United States are making their probate laws much more efficient, and it is possible to go through the probate process without it being unduly burdensome. Some states have provisions that allow you to have really sort of expedited probate process. In Illinois, if your assets are less than $100,000 in value, you can use their efficient process. In Minnesota, if you have less than $75,000 worth of assets, you can use Minnesota's process. The process is very simple. You just have a responsible person file an affidavit identifying themselves, identifying their authority, and promising to honor the rules of the probate law. And then they use that affidavit to collect the assets and pay the bills and distribute them to the people that are entitled to them. Next slide. Some people have property in more than one state, and if individuals have real estate in more than one state, then the likelihood is that at some point they are going to need to follow something called an ancillary probate process. If you have a will, it's desirable to have the will probated in the state of primary residence and have that state's probate process completed. And once that's done, it's relatively simple to commence what is called an ancillary process in whatever other state is involved with the location of the real estate. In recent years, more and more states have been modifying the provisions of their probate rules. It is becoming easier and easier to conduct and complete an ancillary process. So once again, going to probate is not as necessarily overwhelmingly expensive or burdensome. Let's see, next slide. Now, a will is a very good way to distribute assets, but it is not the only way. And in fact, many people are transferring assets through other means. I've been quite surprised over 40 years of practice at the number of individuals whose wills I drafted who ended up not going through probate because at some point in their lives, they sold the homestead, which was the primary family asset, and they took the proceeds of that homestead and they invested them in a investment account, and the investment advisor or the investment company had provided for beneficiaries, in which case that no longer is a probate asset. Another mechanism that a lot of people are using to transfer assets is a payable on death account. So basically that you have a bank account that's in the individual's name, but it has a provision for payable on death. Then when the person dies, the bank transfers the asset to the person who is identified as the recipient of that account. Life insurances policies also have beneficiaries. Another common situation is where you have joint tenancy property, like a homestead with a right of survivorship. In those cases, at the death of the first individual, it is not a probate property because by operation of law of the applicable state, it automatically goes in title to the survivor. But of course, at the death of the second person, it's no longer a jointly held property. So I've worked with many families where at the time that we did the wills, The homestead was not really a part of the estate, but when one spouse died and the other spouse took title, at that point, it became a part of that person's estate, and of course was then controlled by the individual's will. So gifting is another alternative. I'm increasingly encouraging people who have personal property that they want to get to somebody to do it before they die. Partly they get to enjoy the recipient's appreciation of the gift, which is something that provides I think some real enjoyment of life. But also, I've worked with a number of probate proceedings where, when the decedent died, a whole host of people came in and raided the property, and the personal representative had no way of stopping that from happening. And so whoever took it got it, and you can avoid that by donating it to the person you want to have it when you're still alive. Another way to transfer assets is through trusts. There are a lot of companies that promote revocable living trusts, and in some situations, it's a very, very good tool. I specifically recommend trusts if you have a complicated family tree and you don't want to have to invest thousands of dollars to have a company create a family tree, because when you go through probate, you have to identify the family tree and give legal notice to all of those individuals, so that if they want to claim that the will is invalid, they have an opportunity to do so. There are other situations where revocable living trusts are quite desirable. My personal opinion is that they tend to be oversold, that people tend not to actually understand them and end up in a situation where, because they were not properly instructed that they needed to transfer title of their assets to the trust, they now have a situation where they've paid for the creation of the trust, which is usually fairly expensive, and they have probate assets and they've got trust assets, and they end up basically paying for both. So, but their trusts, revocable living trusts, are very desirable in certain situations. So, I think, let's see. I think that's enough for me now. I'm going to turn it over to Tony.
Good morning, everyone, and thank you, Alan and Mark. So I'm going to talk to you all about trust and transfers a little bit more. Alan explained to you the hows of transferring. I'm going to explain a bit more about the whys. Now, Alan already gave you some personal considerations about why you should transfer early. But added on to that, there's also a practical consideration. And the practical consideration we're talking about is taxes. If you're at or near the estate tax threshold, trusts and transfers are going to be vital for reducing your gross estate. And the reason you want to reduce your gross estate is that the estate tax is actually at a graduated rate bracket, meaning that large estates will owe more, or will owe substantially more in taxes than a living individual. For example, in Illinois, the estate tax caps at about 16% compared to 4.5% for individual income tax. That means that if you die in Illinois with, say, $5 million in assets, you're going to be paying $300,000 in estate taxes. And that's just for one individual. If you're married and your assets go to your spouse and they also have an estate that's over $4 million, they also will incur that estate tax if they die. So trusts and transfers are really ways to mitigate those tax consequences. Now, the first thing I want to talk about is gifting, because gifting is a common way to remove or to lessen your gross estate. The caveat there is that gifts made within 3 years of one's death could be counted as part of your gross estate. Now, there's also the other caveat that a gift tax does apply on gifts of more than 17,000. That means that if you give someone, an individual, in 1 year over $17,000 in gifts, then that gets counted towards your lifetime gift exemption. This is a pretty generous lifetime gift exemption of $12.92 million. What that basically means is that if you, over the course of your lifetime, give over $12.92 million, you're gonna have to start paying taxes on that. Most people probably wouldn't get there, but the key takeaway here is that the gift tax does apply and counts towards that exception. There are also other ways to reduce tax consequences. A good estate plan will deduct, delay, and distribute. A good estate plan will take advantage of any credits and deductions you can qualify for to minimize the taxes assessed. A common way is the charitable gift deduction. There's also what I'd like to highlight is the marital deduction. This is particularly useful for married couples. What the marital deduction is an unlimited tax-free wealth and asset transfer to one spouse at any time, including death. That means you can give your spouse, if you're married, any amount of wealth or assets, and that is utterly tax-free. You won't incur any taxes at all, and it's a tool for balancing each other's estates. Take this example into consideration. Imagine if you and your spouse both have a combined estate of $5 million. But if we do the math and we assess your individual estates, of that $5 million, $4 million is yours and $1 million is your spouse. If you gift $2 million to your spouse, that brings their estate up to $3 million, and that brings your estate down to $3 million. In either case, both of you are now under the estate tax threshold and won't incur the estate tax, at least not until one of the spouses die with over $4 million. Another way to reduce estate assets and tax burden is by the creation of a trust. We create a trust, you are creating a way to manage your assets and distribute them to beneficiaries. Now, I want to be clear that this doesn't take away all tax consequences, because individuals will still have to pay income tax on those distributions. But that's still better off because an individual income tax is less than the rate for the estate tax. As I mentioned earlier, the estate tax caps out at 16% in Illinois. But for individuals, it's only 4.6%. Let's talk more about trust. What is a trust? A trust is essentially a way to manage your assets. The key feature of a trust is it's a bifurcated transfer. Whoever the trustee is owns the legal right to the legal title and manages the property in the trust for the benefit of the beneficiary. In a trust, you can create the guidelines for how those assets are managed and how those assets are distributed. And trusts are actually kind of paradoxical because essentially they're easy to make. You can create a trust by simply using the magic words that you are putting an asset in trust guided by a beneficiary you name to be distributed to, guided by a trustee that you name to be distributed to a beneficiary that you specify. With those in place, you have created a trust. Where it gets complicated are those guidelines that you have to draft. That's why trusts tend to become long. Now, you can also set forth directives for minor children or disabled loved ones in trust. That means that just because you're not at that income tax threshold doesn't mean a trust isn't for you. If you have dependent beneficiaries, minor children, or spouses that depend on you, a trust is essential for long-term care. So let's talk about the basics of a trust. This is sort of the terminology you'll see in trust planning. A settlor is the person who creates the trust. In some states, they're also called the grantor. The trustee is the person you appoint to supervise or manage the trust. A trustee has a fiduciary obligation to the beneficiaries, which means essentially that they can't self-deal, that they have to keep the beneficiaries' interests at heart, and also they can't do anything illegal. The beneficiary is the person who benefits from the trust or for whom the trust exists. I want to draw attention to this because with trust, you can actually have more than one beneficiaries in the sense that one person can be the lifetime beneficiary who will receive the trust income throughout their lives, and then the other person can be the residual beneficiary. When that lifetime beneficiary dies, the residual beneficiary gets everything, the principals or the income, depending on the setup. A key feature of a trust is it's very flexible. The same person can be the settlor, trustee, and beneficiary of a trust simultaneously. But again, watch out for that fiduciary duty. You as a settlor can create the rules of the trust, including what beneficiaries get and what circumstances they get those benefits. You can also determine who the successor trustee can be, and a good estate plan will also consider ways to appoint trustees if those successor trustees are no longer able to serve. A trust is a very flexible tool, and your only limit is really your creativity. Of course, you can't make trusts for anything illegal. Like, for example, you can't create a trust to support organized crime. The common types of trusts are a testamentary trust and a living revocable trust. Alan mentioned living trust a little bit earlier, but I'll talk a little bit more about it. A testamentary trust is a trust that's created by will. This is an irrevocable trust because, well, by the time this trust is created, you'll be dead. A living revocable trust is a trust you create during your lifetime. This is a trust made usually so that you as the living settlor can enjoy the benefits of whatever asset you put into the trust, and also ensure that when it comes time for you to die, that the asset passes cleanly by operation of law to whoever your named beneficiary is. This is probably the most popular trust instrument that you'll see out there. Most trusts that you'll see usually start off as living revocable trusts. And the biggest benefit for this is that the person that created the trust can make changes to the trust and revoke the trust at any time, at least until they declare the trust to be irrevocable. The wills versus trust, which is a better option for your needs. That really depends on the types of assets you possess, the beneficiaries you have, and the complexity of your asset management. An easy delineation is that a will is useful for outright bequests. If you want to plan for more long-term management, a trust really is the way you want to go. This is just a list of trust purposes. As I said earlier, the limit to your trust purposes, you can get really creative for purposes for trusts. Revocable living trust puts assets in your trust during your lifetime to manage as you see fit. A testamentary marital trust is a built-in trust that transfers a portion of assets to your surviving spouse. A charitable trust for supporting charities. Support and discretionary trust for watching out for your beneficiaries, your dependents, minors, children. And I'd also like to highlight their land trusts. So the two trusts I'm going to talk more in depth about are going to be credit shelter trusts and land trusts. What a credit shelter trust is a trust created to hold assets separate from the estate of a surviving spouse. This is to avoid probate and also to ensure long-term care for your contingent beneficiaries. A trust like this is designed to pass assets tax-free to remaining beneficiaries after the death of the surviving spouse. The real downside for this type of trust is it doesn't really give your spouse a lot of control over the assets. So if you are planning for the care of your spouse, what you'll really want to set up is a marital trust. Now, a marital trust is irrevocable. It's a trust created to hold assets separate from the estate of the surviving spouse, meaning that surviving spouse won't count those trust funds as part of their estates when they die. The spouse can use the funds of that trust to benefit themselves with added tools so that they can exert more control over the assets itself. Like the credit shelter trust, this is also designed to pass the assets tax-free to the remaining beneficiaries after the death of the surviving spouse. And this can go either way as a pro or con, but the surviving spouse retains a lot more control over the trust itself. These two trusts can benefit you and keep wealth in your family by reducing your tax consequences and giving you a way to manage your assets. The Illinois Land Trust. So this is a type of trust that is a unique beast to the state of Illinois. It's an alternative way to hold and manage lands. A recorded deed is held by a trustee, and rights and conveniences of ownership are enjoyed by the beneficiary. The pros of this type of trust is that it's less subject to market forces. You can transfer the property outside of a market transaction. This trust also gives you a lot more privacy and ownership because the deed will be held by the trustee, so the true owners are not public. Although there are situations where this can be piercing the veil of privacy when there's very specific legal issues. The other added benefit to a land trust is continuity. The succession of ownership is guaranteed by the trust provisions and effective upon death without need for any probate court proceeding or any kind of other legal planning. So continuity is an important tool here to keep this sort of real estate within your family sphere. The cons of an Illinois land trust is that it's not really recognized in the majority of states. So if you have interstate dealings, that may complicate those, and there might be added steps to effectuate those sorts of deals. It's also not a total shield against liability. I think there's a popular misconception that putting the land in trust then shields you from liability, but the truth is merchantability of the land can still be encumbered by liability stemming from co-owners or other beneficiaries. If you put land in a land trust, you're also forfeiting redemption rights for foreclosures. There's a potential to lose the homestead exemption, and you aren't qualified for any secondary market loans. So those are the cons of a land trust. The last type of trust I'd like to talk about is the conservation land trust. Like I said, an Illinois land trust is very unique to Illinois and to a few other states. When you talk about land trust everywhere else in the country, they're probably talking about a conservation land trust. What a conservation land trust is it places property under a conservation easement, and the landowner actually surrenders development rights. And this is mainly used for conserving undeveloped land for public benefit. So think public parks, nonprofits. And the key benefit to this type of land trust is that it's perpetual. And I think that's it. I'm going to hand it over back to Mark.
Okay, thanks everybody. In the interest of time, I'll go through. So, Tony, next slide, please. Thank you. So some other topics. Alan went in detail over wills. Tony went in detail over trusts, which are the two biggest parts of the estate planning process you'll do. In addition, with our firm, or just about any firm who practices in this area, your estate planning attorney will also want to talk to you about a healthcare directive, sometimes referred to as a living will, sometimes a healthcare power of attorney, sometimes an advanced directive. I know in the state of Illinois, the Illinois Department of Health has standard forms for these. But what this is many of you probably already have them already, or you've been asked about them, or you have family members with them, which in the event you're in need of emergency medical care and you can't communicate, and you have specific wishes about, do you want to extraordinary measures to be taken for you, that can be spelled out in one of these documents appropriately. And those are typically what you're going to be doing with that is you're going to be notifying the person who you want to be your agent to make those decisions for that spouse or family member. Typically, you're going to want to have this on file with your primary care physician. So also another important estate planning document we do is we almost always have people execute a power of attorney. Power of attorney is basically a way to allow you to grant legal authority for somebody else, referred to as the attorney, in fact, to make decisions or conduct transactions on your behalf. Somebody of your choosing to handle your financial matters, someone with your power of attorney You grant that over, they can open or close a bank account for you. They can sell real estate. They can do any number of things. So that's something that will often come into play. I know Alan talks about this really more often than a will or a trust, about that will, the need for that will come up. So that's something you're also going to want to talk to your estate planning attorney about, and have your estate planning attorney go through with you why you're having it, how you should use it. Fourth one here, statement of disposition of tangible personal property. This ties into what Alan mentioned about the list of tangible personal property referenced in your will that states specific bequests. Typically in a will, there will be a paragraph saying, of my personal property, I want that to be disposed of in accordance with the list that I've provided, which is referenced herein. The thing about that is somebody's got to know that that list exists. Somebody's got to know where to find it. You use it for things like jewelry, furs, artwork. We've had somebody do it with classic motor vehicles. We've, and also Alan talked about how it's his personal recommendation. Hey, why don't you give that away during your lifetime? Then you have control. Beneficiary designations. We talked about this a little bit, about how this will be something that'll be part of retirement accounts, insurance policies, have property go, have assets go outside of the probate process, outside of the will or trust process, but directly through one of those instruments themselves. What I like to add to this is what we also do with our clients is we draft for them a letter for their signature that they will give to who they're going to be asked to be their executor or personal representative or trustee or agent. That will say something to the effect of, dear so-and-so, thank you very much for agreeing to serve as my personal representative. This is very important to me and means a lot to me. What I will want you to know is here's the things that I have. Here's where you need to find them. My will is located here. My trust is located here. I have retirement accounts here. I have life insurance with this company. My lawyer was this person. There's their contact information. Please keep this letter in a safe place, and so you can access it when you need to use it. So why don't we, next slide, please. Also want to talk briefly, and we've touched on this before, about the risks in failing to plan. This is part of our explanation about why this should be important to you. If you don't have a will, the laws of intestacy, that is dying without a will, apply. Taxes may not be mitigated. Guardians for minors and dependents may not be appointed, or they'll be appointed by somebody else who's not you, such as court. Family might be financially or personally burdened while the assets are in probate. A will allows you, as we've discussed, to design around that, to plan around that. A healthcare directive or living will allow you to address in advance those needs. So next slide, please. Again, about intestacy, and just to put a point on why it's not desirable. The goals of intestacy, which what we mean by that is we're referring to a state law scheme that says if you die without a will, this is how it'll work. Many of you may have heard the phrase before, if you don't have a will, the state has written one for you. That's what intestacy is. That's how it works. Its goals, through designed by the legislature, are to ensure a very basic disposition of the property, make sure that valid debts are paid to the creditors, and then have your heirs inherit, who are typically family members. And it's not ideal because of the reasons we've described before and what we're listing here. So we have an illustration of that. Next slide. Heirs will typically include spouse, registered domestic partners, blood relatives, and then other than heirs, the only people who are going to get your estate are going to be approved claims of creditors. And then also the heirs will receive what's a specified intestate share. And again, this is all planned by through the statute. And The heirs and testate shares will be distributed by a personal representative who's appointed by the court, who is not necessarily someone you desire. Next slide, please. Just to give you, yeah, this is the illustration we wanted to talk about. Under Illinois law, and I want to look at the family situation. If you don't have a spouse, but you have children, your children will each get an equal share of everything. If you have a spouse, but you don't have any children, and what we mean by children are lineal descendants, biological or blood relatives, as well as adoptees. It does not include stepchildren. So if you have a stepchild you want to provide for, you're going to need a will and or a trust to do that. And then an interesting one, I think, of the third row is under Illinois law. If you're married and you have children, biological or adopted, the default provision in the laws of intestacy in Illinois that spouse inherits half and the children will equally split the other half. So I think with that, let's go to the next slide. I think we have, and we're now ready to go back to, who do I turn this back over to? I believe Erica, it's back to you, right?
Wonderful. Yes. Okay. I'm trying to give you video. Wonderful. Okay. Thank you so much for that. We'll leave a minute for the contact information for J. Selmer Law. And then once you have a chance to take that down, I'll ask you, Tony, if you can stop sharing and I'll share the next slide. So thank you very much. That was a wonderful presentation. I myself learned a lot, and I believe from the number of people who remained on the call until the end, we still have over 75 people in this presentation. So I can attest to the fact that a lot of people found value in this presentation. So with having 75 people, that is a wonderful thing. To have the chance for question and answer, it would be a little bit better to have smaller groups. So what we're doing is we're trying something new, and we're offering those opportunities for people to not only have the chance to ask questions, but also review the checklist that was mentioned earlier. So what we're going to do is, let me share this for you. We will offer the opportunity to break out into small groups. So hold on one second. Let me share this so you can see it. Okay, so these are going to be the breakout rooms, and they will be organized by the first letter of your last name. So what we're going to do is, I'm going to share in the chat. Once I stop sharing my screen, I'm going to share in the chat the links that you can click on to join your breakout room. So again, room 1 will be for any guest, any participant or attendee whose last name starts with A through G. Room 2 is for any attendee with H through M as a first letter. Room 3, any attendee with the letters whose last name starts with N through R. And room 4 is for any attendee with the last name S through Z. So again, that is the format. Let me stop sharing so I can give you those links to click on. One moment, please. Okay. So again, to allow for those opportunities, please take a look at, I just provided that in the Q&A, the links for you to join, and the information about how, who's divided into what room. So again, we invite you, whenever you're ready, you can go ahead and leave this presentation and you can click the link to join the new presentation. This will give you the opportunity again to be in a smaller group and to have access to those attorneys to ask your questions, and also to see in more detail what is involved in that checklist that they have shared with us. So I see the numbers are going down, so it looks like people are leaving to join those breakout rooms, and I invite you to go ahead and do that. I'm going to stay here for a few more minutes to help people to navigate and go where they need to go. But yeah, those numbers are going down, so I think people are joining. But we want to thank you again for joining us. For those who are still here, this has been an awesome presentation, really wonderful content. We really appreciate both JP Morgan Chase and J. Selmer Law. Thank you so much for providing this information to the audience. And yeah, okay, so the numbers are still going down. People are still logging out and joining those breakout rooms, so that's great. Getting down, down, down. Wonderful, wonderful. Thank you again, John. This was really, really awesome. Thank you so much. Okay, still going down, still going down. People are joining their breakout rooms, which is great. Again, we hope that this information was valuable and helpful to everyone. And yeah, okay, still going, still going. Oh, there's a question here. Can we have a copy of this presentation? Yes, this presentation was recorded and will be made available to everyone. And we will share that information with you. Okay. We see that there are still some people on the call. If you have a question, please go ahead and type that. Please, add that to the Q&A and I can help you if you need to navigate or if you have any follow-up questions. But otherwise, please feel free to join the breakout room. Great. Yes, Katie, that's great. Yes. Thank you. We're all done. So thank you, everyone. I am still keeping an eye on the chat and the Q&A. Okay, so please provide contact info. So I'm assuming that contact info is mine. So my email address is erica.miles@cicchicago.com. And that's Erica, ERICA, last name MYLES, erica.miles@cic.com. Okay, any other questions that I should answer? Hi, Mark. No, now you're Alan, but you're showing
Alan.
under Mark's name. Okay.
Yeah, I'm having trouble getting to where I need to go.
Okay. All right. I think John has, I'm not sure which room John assigned you to. So I think you might want to reach out to him and see where he wanted, because I have the links, but I don't know which room he wanted you to join. So John might have more information about that.
How would I get to John?
You might want to shoot him a quick email or maybe give him a call. Yeah, that we don't have a list of which attorneys were joining which rooms. Okay. All right. It looks like there are a few people remaining on the call. Let's see who's there. So, okay. All right. So for those who are, let me allow you to talk. How about that? Okay. So if there is anyone who still has a question, please let me know. Otherwise, I'm going to go ahead and close this meeting since people have had a chance to go ahead and join the meeting rooms. Okay. All right. So thank you to everyone for joining us. And I'm going to go ahead and close this now. I don't see any questions, and I think we're all set. All right. Thank you, everyone. Thanks so much for joining us. Oh, it looks like Quentin, you have a question? Okay. Quentin Ellis, are you there? Okay. Maybe that's from earlier. All right. Thank you, everyone. I'm going to go ahead and close out this webinar. Thank you so much for joining us and enjoy the rest of your day. Thanks.